And the next case to come before the court is Rafal, Stachowicz et al. V. Stephen W. Moore Building Corporation Limited et al. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time for rebuttal, please let me know, as I'll be keeping track of time. The arguments are being recorded. Please keep your voices up and remain behind the podium. You shouldn't use the names of children or minors or victims, should that be relevant to your argument. The judges have read your briefs. We're ready to proceed when you are, and I would just ask the appellant at this time, would you like to reserve time for rebuttal?
Yes, Your Honor, 3 minutes, please.
3 minutes. Okay, then you may proceed when you are ready.
Thank you. May it please the court, my name is Mark Sanchez, and I'm here today representing Rafal and Stachowicz. I know you all have already read the briefs and the cases and are very well informed regarding what's going on here. I think what I'd like to do today is really just take a little bit of a deep dive into the Home Solicitation Sales Act. There has been, my firm handles a bunch of these cases, and there has been some overlap relative to the Consumer Sales Practices Act and the Home Construction Service Suppliers Act, as you know, that came out in 2012. So, I think here the important fact is that for things like shoddy work and failing to repair, things like not pulling permits and beginning the work on a residential construction project, and things like abandoning a residential construction project, those are clearly the overlap between the Ohio Consumer Sales Practices Act and the Home Construction Service Supplier Act that we saw, and we see the distinction there in Megapools, the Beater case, and some other cases. That is not what we're talking about here today. I think in my notes, what I wrote is that the universe of home residential construction contracts is very, very, very large. And just a very tiny part of that is going to be residential new home construction contracts that are personally solicited at the home. And they're very different. They're not mutually exclusive things. It's not one or the other, like you get with this with the typical violations that I just ran down: the shoddy work with the no repairs, the abandoning the site, the failure to pull those. Those are clearly, it's one or the other. It's either going to be a renovation job that falls under the Consumer Sales Practices Act, or it's going to be new home construction that falls under the newer statute that came out in 2012, that Home Construction Service Supplier Act. And I think the arguments here that the Home Solicitation Sale Act claims are somehow preempted or voided out by the existence of the Home Construction Service Supplier Act, what they try and do, what the argument does is it conflates those two very separate and two very distinct acts simply because they fall under Chapter 1345 of the Ohio Revised Code. And as I noted in the brief, the Consumer Sales Practices Act is only subsections 1 through 13 of Chapter 1345. And the Home Solicitation Act is a completely different part of that chapter. And it's a completely different act. It's designed to prevent different things. It has a different purpose, different legislative intent, different wording, etc. They're not the same. And they can't be conflated to say that this is new home construction, therefore the Consumer Sales Practices Act does not apply, which I understand when you have the typical violations. But the not having the 3-day cancellation language, not having the notice, the cancellation form completed in duplicate and handing that to the consumer at their residence while you were personally soliciting the new home construction contract at that time, that's very different, and that's not an overlap. So when I go through and I looked at the cases that Stephen W. Moore cited, and I think they're both very distinguishable. I think for the first time here, or based on what I've looked at, this is the first time we're going to have a statutory analysis and really look at, all right, here are these three acts. How do they interact with each other? Does one preclude the other? And how do they interact? And I think you have my position from the briefs that the Home Solicitation Sales Act certainly is an act, and it is a consumer protection law that is in addition to and separate and apart and distinct from the Home Construction Service Supplier Act, which came out again in 2012. So the three errors, alleged errors that we have here is the finding by the trial court that the Home Solicitation Sales Act can never apply to contracts for new home construction services, even when the contract was personally solicited at the customer's or the consumer's residence. And I don't think that that type of pronouncement is warranted here, just based on a straight reading, of the statute. Whether we like it, whether we don't like it, whether we think it creates too much of a hammer in the hands of consumers, right, for these types of cases, that's not what we're here to decide today. We're here to decide today is what does this statute say, and how are we going to apply
Are
it?
we here to decide that today? Because my understanding is that the trial court didn't have a hearing on the motion to compel arbitration.
Right, and it's always confusing to me, that chapter 2711, as you rightly point out, motion to stay, I think the rule is you don't have a hearing. Motion to compel, yes, you do have a hearing. And that's been an issue a lot going back and forth here. And I thought,
But this district has ruled that you must have a hearing.
to compel,
Correct.
right, for sure. And I think that's the correct interpretation of 2711, whatever it is, .03. That you do have to have a hearing before you compel. Now, I can look at the order here. I thought that Judge Kimbler just said stayed. So if it's just a stay, I'm not sure. But certainly that is an important question. It's a good question, and we come up against that frequently. And a question I know is, does the movement have to request a hearing? Is the requirement for a hearing waived if they don't request it? Things like that. But, that's the secondary question here, and really is, does the Home Solicitation Sale Act apply? Then if it does, then when the Stachowicz did cancel the contract via that letter, and then in the brief, I think Wisniewski pretty clearly says that, yes, that cancellation of the entire contract cancels the entire contract, including the arbitration provision that's contained within that contract. So those are two issues that kind of go together. And then the last issue, and I really didn't understand why the trial court felt that they were going to rule on the merits of one of the underlying claims, because there's basically two. One is the Home Solicitation Sale Act, that's count one, even though the title says Home Solicitation Sale Act and Consumer Sales Practices Act. I mean, that's just the second part of that is just the remedy, right? So the Home Solicitation Sales Act, that has different definitions, it has different tests, in order to make out a claim. And then the one part of it that links it back into the Consumer Sales Practices Act, I think is 1345.28, that says, violation of the Home Solicitation Act is a violation of the Consumer Sales Practices Act. And I understand that the Stephen W. Moore kind of hooked onto that to say that they are the same thing, and that the Home Solicitation Sales Act is preempted by the existence of the Home Construction Service Supplier Act, but that's just for the remedy. And that's really what I wanted to say here today. That's just the remedy. So even if the only remaining remedy, I don't think that applies, okay? I want to make sure that I'm clear on that. I don't think the definitional section that Stephen Moore is relying upon, I think that applies to .01 of 1345 through .13. I don't think it applies to the rest of the statute. And frankly, I looked at the statute, chapter 1345, and there are a lot of different things in there. I mean, it's not just Home Solicitation Sales Act, Consumer Sales Practices Act. There are rules and regulations, and I didn't know this, about how you have to switch from a natural gas provider or a public telecommunications service provider. There's sections on hearing aids, prepaid entertainment contracts, invention development services and non-conforming new vehicles. So again, these are really two separate statutes, and I think that for, I'm going to say intellectual honesty, we really have to look at the statute and really have to look, did the Stachowitzes make out a prima facie case of a violation of the Home Solicitation Sales Act? And that is the question. And was it proper to dismiss that before we get to any facts, et cetera, at the 12B6 stage? So I think really that's all I have. The issue with the ruling on the Home Solicitation Sales Act and then sending the remaining claim, so dismissing count 1 of the complaint and sending count 2 only to arbitration, I had to really look at that and see if that is proper for a trial court to exercise jurisdiction on the potential merits of an underlying claim before submitting it to arbitration, because I wasn't quite sure on that. And then I looked at these cases, which are at page 11 and 12 of the Stachowitz's brief, and it's very clear from the United Supreme Court to the Ohio Supreme Court to the Courts of Appeals here in Ohio that's improper, and that is, even if it is frivolous, and the trial says, yeah, this thing really can't stand, you have to send the whole thing to arbitration. So,
But counsel, in this particular situation, perhaps it's a little different, because one of your arguments was that it didn't have to go to arbitration because this was a violation of the HSSA, and if that was the case, then the arbitration provision was void.
right.
So the first thing the court would have to do is determine whether this contract was within the requirements or the confines of the Home Solicitation Sales Act.
Right. I think that's correct, and I think that goes back to your point, is was there a hearing? Should there have been a hearing? Was there a determination that, I disagree with you a little bit. Yes, you can go through that analysis, but the end result will be everything goes to the arbitration.
But I guess I'm having a hard time if you say it's not. The court makes a legal determination, because it has to make that legal determination to know what to do for arbitration purposes, whether or not it's even arbitrable. Because you're arguing that the contract was void,
Right.
and you're saying you don't have to go to arbitration.
Right.
And in order to get to that point, though, your contract has to be subject to the Home Solicitation Sales Act.
And I agree with you.
Okay, so the court had to make that determination first in order to know how to handle arbitration.
And counsel, I just want to let
I'm
you know
sorry.
you're moving into your rebuttal time.
Okay. I just want to answer that question, and then, if we even need a rebuttal, who knows? But my thought, in my opinion, is that is fine to go through that analysis, but the proper conclusion to that analysis is not dismissal. The proper conclusion is the motion to stay, and to the extent there's a compel in here, that is granted, go to arbitration, not count 1's out, we chopped it out, it's dismissed, 12B6, and you can only proceed, because the way it stands now, I can only proceed on my count 2, and that.
And I don't mean to belabor the point, but I'm trying to figure this out myself. When I was reading it, the first thing I thought of, how does the court then deal with its legal determination that the HSSA is not applicable, but yet send it to arbitration, even though the court has made a legal determination?
They can make that legal determination, whether that's res judicata or somehow binds the arbitration panel on the back end of that, I don't know. But dismissing it outright, I don't know if that's the right decision. And should we have had a hearing? I don't know. That's up to you all.
Thank you very much. You'll have a little over a minute and a half for rebuttal.
Thank you, Ron.
Thank you. You may proceed.
Thank you, Your Honors. May it please the Court, Your Honors, Counsel. My name is Amanda Weber, and I represent Stephen W. Moore Building Corp. and Stephen Moore, who is present in the courtroom today. And we are here today because my client built, the appellant, a $3 million home under a new home construction contract. And they no longer wish to pay for that home. New home construction contract. That is the operative phase. Because it sets forth the playing field for the parties' agreement. New home construction contract is governed under Chapter 4722 of the revised code. It's in the playing field over here. It has a unique set of rules, a unique set of requirements, and its own unique remedies. Appellant, as the court knows, entered into a new home construction contract with my clients on April 14, 2019. And I know the court's read the briefs and is aware of the facts, so I won't go into too much detail, except to say that the agreement was for the construction of a new home, a residential home. That fact is not disputed. The applicability of the Home Construction Services and Suppliers Act is not disputed by the appellant. In fact, count 2 of their complaint indicates violations under that statute which have been stayed pending arbitration by the trial court.
So that's what you think the order says, stayed, it's not compelling arbitration?
I don't read the order as in compelling arbitration, I read it as in stayed. There was no request for a hearing on a motion to compel, and the order reads simply stayed. And I read that order as staying the case pending arbitration on the Home Construction Services and Suppliers Act claims, because there was not an argument before the trial court that the arbitration clause didn't apply to the Home Construction Services and Suppliers Act. So there was not a dispute or a reason to compel arbitration on that remaining claim. Since the Home Solicitation Sales Act and Consumer Sales Practices Act are inapplicable, the contract could not have been canceled, which means that the arbitration clause is valid, and the only remaining claim is the Home Construction Services and Suppliers Act claim, which was not disputed to be subject to arbitration by the appellants in their brief. So there was no reason for the
contract
court.
itself.
So-
I'm sorry,
Go
if the arbitration provision itself is not void.
So because.
That's correct, Your Honor.
We're tag team.
I'm sorry, go ahead.
In order for the arbitration clause in the contract to have been void, it would have had to have been procedurally or substantially unconscionable. There would have had to have been some argument made or position posted before the trial court indicating why the court should not stay the proceedings with respect to the Home Construction Services and Suppliers Act claim pending arbitration, and there was not. So that is the reason that it did not need to be compelled, but simply stayed so that issue could be resolved. With respect to the applicability of the Home Construction Services and Suppliers Act, I'm sorry, let me rephrase that. With respect to the applicability of the Home Solicitation Sales Act and the Consumer Sales Practices Act, the review of the statutes, the definitions of those statutes, the interrelationship of those statutes, the remedies in those statutes, and the case law in the state of Ohio all provide that those statutes are not applicable to Home Construction Service and Suppliers Act or new home build cases. And when you're looking at the definitions of the statutes themselves, for instance, under the Consumer Sales Practices Act, a consumer transaction is defined as a sale of goods and services, and I won't read the entirety of that statute, but I'd point the court to the sale of goods and services. So when you look at the definition of a home solicitation sale, it's the sale of consumer goods and services in which the seller engages in a personal solicitation. Seller, a supplier under the Consumer Sales Practices Act is defined as a seller under the Home Solicitation Sales Act. So all of these definitions interplay. What also interplays is the remedies that are available for someone asserting causes of action under the Home Solicitation Sales Act. If you look at appellant's complaint, you'll note count 1 of the complaint, the count that was dismissed, asserts cause of action under both. Appellants argue that those statutes are not related, and this court should create a narrow or myopic interpretation of the Home Solicitation Sales Act to keep it separate from the remaining portion of the statute. But even in their own complaint, they've alleged counts under both provisions because of the interrelationship from the statute. A violation of the Home Solicitation Sales Act is a violation of the Consumer Sales Practices Act. You violate the Home Solicitation Sales Act, it's a deceptive act. You don't have remedies under 1345. You don't have one without the other. This is why the Consumer Sales Practices Act was specifically amended to exclude new home construction contracts. The legislator meant to separate these types of contracts from home solicitation, door-to-door sales. And when you look at the case law that's interpreted these statutes, there's no court in Ohio that's held that the Home Solicitation Sales Act applies to new home construction after the enactment of the Home Construction Services and Suppliers Act in 2012. The 12th District case, which I believe appellants attempt to distinguish in R.J. Long and Associates, the 12th District Court of Appeals specifically found that the Home Solicitation Sales Act is not applicable to a new home construction contract and states that there's no case law in Ohio finding that it is applicable. Although appellants today ask for you to take that narrow interpretation to create a district split and find an opposite of that, despite the interrelationship and statutory language that suggests otherwise. The R.J. Long and Associates case, it did involve a contract for new home construction. There is a little bit of distinguishment in this case in that the home builder and the homeowner settled their case, and the subcontractor of the home builder files suit against the homeowner for unjust enrichment because the homeowner doesn't pay the subcontractor as it had agreed with the home builder. But in that case, the homeowner attempts to use the Home Solicitation Sales Act as a defense, as a shield for not paying the subcontractor that she had agreed to pay. And the court said, no, the Home Solicitation Sales Act doesn't apply to new home construction, and oh, by the way, even if it did, we're not going to allow you to use the Home Solicitation Sales Act as a sword. It is meant to be a shield to protect consumers in high-pressure circumstance. And when you look at the Home Solicitation Sales Act, that's what it's for, high-pressure, door-to-door sales, those in-person sales, and to protect the consumer for those types of transactions. And new home construction, a $3 million home, is not one of those types of cases, which is why the legislator sought to distinguish those contracts in enacting the Home Construction Services and Suppliers Act. If you look at the statutory language of the Home Construction Services and Suppliers Act, I think that's important in telling as well, because if you look at the remedies under the Home Construction Services and Suppliers Act, there is no interrelationship between the Consumer Sales Practices Act and the Home Solicitation Sales Act. It has its own remedies for rescission. It has its own remedies for attorney's fees if there are violations found under that statute. But what it doesn't do is implicate the Home Solicitation Sales Act, which the Consumer Sales Practices Act does, because the one is a component of the other. In our brief, we also cited two cases, the 11th District and the 5th District case, and while they are considering issues a little bit different from the issue before the court today, they are deciding that separation between the two statutes. And in those cases, there are home service contracts where the Consumer Sales Practices Act and Home Solicitation Sales Act are applicable, but the preference would be for the Home Construction Services and Suppliers Act to be controlling. The courts in those cases find that the construction of existing home construction does not implicate the Home Construction Services and Suppliers Act. It indicates that the Home Construction Services and Suppliers Act are for new builds, while those other statutes are for these service-type contracts. So those courts are also making the distinction between those two playing fields, which are important here today. The contracted issue here is governed by the Home Construction Services and Suppliers Act. The Home Solicitation Sales Act is a component of the Consumer Sales Practices Act, and new home construction contracts were specifically excluded. Therefore, the court, in making its decision to dismiss those claims, made the right decision. It interprets those statutes correctly and finds that they're not applicable and dismisses those claims. And turning to whether or not there should have been a hearing with respect to arbitration and the arbitration issues raised in appellant's complaint, I would note to the court that he does not argue that there should have been a hearing. That's not an issue that's raised in his complaint with respect to arbitration. I would also point out to the court that in appellant's argument, first they indicate that there should not have been any referral or hearing with respect to arbitration at all because they believe their case should have proceeded before the trial court. They invoked the jurisdiction of the trial court despite the language in the arbitration provision. They don't dispute the applicability of the arbitration provision or the validity of the contract itself, but claim that it should not have been before the court, or claim that it should have been before the court because the Home Solicitation Sales Act would have canceled their contract. Since the contract's not canceled, because the Home Solicitation Sales Act is inapplicable, that means that the only remaining cause left is the Home Construction Services and Suppliers Act claim. That's not disputed that it's subject to arbitration. I think that this recognition by appellant is seen in his third argument before the court today and his issues presented for review because he asked the court to make an alternative argument. First he says that the court shouldn't have stayed the case pending arbitration and the court should have proceeded in the trial court because the Home Solicitation Sales Act is applicable, but then he says, but if it's not, then the court should have stayed everything because these claims are all arbitrable. So he's not disputing the underlying arbitrability of those claims. So without disputing the arbitrability of those claims, what he's left with is having invoked the jurisdiction of the trial court, yet after not liking the decision of the trial court saying in his third issue presented for review, wait a second, maybe all of these claims should go back to arbitration. And you don't get two bites at the apple, so the law doesn't allow that.
Well, I think what he's arguing is that the court has a duty to determine arbitrability, okay? And then once the court determined arbitrability, then the court should send everything that was in the contract to the arbitrator. And then the arbitrator makes the determination whether it's valid or not.
And I certainly would agree that the court has that decision to make on whether or not claims are arbitrable, but if they're not disputed to be arbitrable, then they no longer have to make that determination. And I think that that's the distinction. The appellants never dispute that the Home Construction Services and Suppliers Act claim would be subject to arbitration. The only reason that they claim that the case is not subject to the provision is because of the applicability of the Home Solicitation Sales Act. So once that's removed, there's no reason to make the decision on arbitrability because it's not disputed. In conclusion, Your Honors, the court properly has dismissed the Home Solicitation Sales Act and Consumer Sales Practices Act claims. Those claims are specifically excluded. The new construction contract claim is specifically excluded under those statutes. The statute that governs is the Home Construction Services and Suppliers Act, and there's no dispute that that issue is an issue that is arbitrable, and this case should have been stayed pending arbitration. Are there any remaining questions from the bench?
Hearing none, we thank you for your presentation.
Thank you, Your Honors.
And might I say, you finished exactly on time.
Thank you, Your Honor.
Counsel, you will have 1 minute 33 seconds for rebuttal.
93 seconds, thank you.
Thank you.
I just have 3 things to say. Number one, with respect to the issue, was a hearing required in the trial court pursuant to 2711.03? I don't know. The motion filed by Stephen Moore in the trial court was a motion to dismiss and motion to stay litigation and compel arbitration. And at page 11, they do reference 2711.03. So, don't know. The second thing is, again, with the consumer transaction language that Stephen Moore argues somehow puts the Home Solicitation Sales Act and combines it with the Consumer Sales Practices Act, and therefore the Home Construction Service Suppliers Act preempts it. That language is only found in that 1345.28, which is the one section that says, the violation of the Home Solicitation Sales is a violation of the Consumer Sales Practices Act. However, 1345.22 is separate, distinct, and apart from all that, and that's what allows cancellation. So even if their argument is correct, I don't believe it is, the remedy of cancellation still remains. The last thing is just a word on the R.J. Long 12th Appellate District case. There was no personal solicitation at the residence there. It was the defense of an unjust enrichment claim. There was no statutory analysis. The homeowner had already agreed with the general contractor that she was going to pay off the subcontractors, and there were no complaints about the work, and everything was accepted. So I think it's really different. So I thank you for the extra 90 seconds. Thank you very much.
Thank you, counsel. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. On the day that it's released, the Clerk of Courts will mail a copy of it to you, and it will also be posted on the Ohio Supreme Court website.